challenges where that is concerned. If at any point during question and answer sessions, you wish to be a part of the session, you need to make a contribution, there are options that you have. There is the raise hand section, and for those who don't know where it is, in the bottom bar, take a little time to familiarize yourself. You will see a smiley face. If you click on it, at the very top of it, you will see a raise hand. And there are other symbols there that you can use to express your reaction to what is happening and applaud and so on. You may also use the chat feature, and we expect you to use that exhaustively. We will be monitoring the chat, and if you use the chat, you will get an opportunity to say what you want, and we will help to filter it into the meeting as best as we can. With that said, I would like to take this opportunity to welcome those of us that are here. The fabric of our family and community structures, they're buckling under the weight of domestic and gender-based violence. Homes and communities which were to have been safe places, safe havens, have become battlefields. The rank of the abusers seem to know no boundaries. They are pastors, politicians, law enforcement officers, and I hope no justices of the peace. The victims also seem to know no boundaries. Their ages are getting younger and younger by the day, and it is almost taken us over. As members of the Fraternity of Justice Providers, domestic violence and gender-based violence are critical issues to be sensitized on, and that is why this afternoon the Ministry of Justice has collaborated with the Ministry of Culture, Gender, Entertainment, and Sport to bring to the table much information that will be required for us to be better at being gender-based advocates. I'd like to acknowledge tonight persons who are here. The Honorable Delroy Chuck, Minister of Justice, the man who seemed to have more energy than some of us who are younger than him. I was in a meeting with him this morning, and I know he had several others, and he looked as fresh as he was this morning in the meeting, sir. The Honorable Babsy Grange, the Minister of Culture, Gender, Entertainment, and Sport, again, a very hard-working minister. We also acknowledge the presence of the Permanent Secretary of the Ministry of Justice, Mrs. Grace Ann Stewart McFarlane, and we acknowledge also the Permanent Secretary of the Ministry of Culture, Gender, Entertainment, and Sport, Mr. Denzel Thorpe. We have our Chief Technical Director from the Ministry of Justice, Mrs. Charmaine Creary Beckford, along with the custodians from each of the parishes. Ms. Karen Wilson, Director of Legal Affairs from the Ministry of Justice, is also here with us, along with the Director Principal of the Justice Training Institute, Mrs. Karen Campbell Basco. The presenters, Reverend Ian Meerhood, Mrs. Sharon Coburn Robinson, and Miss Georgette Grant, I will introduce more extensively when their time comes. There are other officials with us from the Ministry of Justice, the Ministry of Culture, Gender, Entertainment, and Sport, and of course, our most valued JP, members of the media, and anyone else from the justice and gender fraternity who believe this is a place for them. Let me take this opportunity to not only welcome you, but to invite the person, Miss Anisha Lancaster. I almost say Minister Anisha Lancaster. She is the policy analyst for the Ministry of Justice, to pray a blessing over all of us tonight.
Good evening, all. Let us pray. Almighty God, who is faithful in all things, we come before you this evening, not because of our goodness, not because of our righteousness, but because of your mercy and your grace that has been extended towards us. And Lord, as we come this evening, it is a very divisive area that we are going to be discussing, Lord. Many have been made to grieve over this matter, dearest God. And so we pray even now that the presenters will present with clarity and purpose, and that they will give direction to this group as to how we can help someone in our community who has been affected by gender-based or domestic violence, dear God. We pray, Lord, for the ministers that are on, the permanent secretaries, and all the other members of government, Lord, who continue to fight the good fight in helping people to better serve in their community. Lord, bless this evening's proceeding as we tell you thanks. In Jesus' name, amen.
Amen. And as we all say amen, we jointly acknowledge and welcome the presence of God in this meeting. We have some remarks. We have some remarks, and I really enjoy the amen, but it is a reminder that some of us may not have had our mics muted. We have some remarks, and we have firstly the Minister of Culture, Gender, Entertainment and Sport. She speaks passionately about the concerns, and she speaks for women across this island and indeed the Caribbean, followed by our Honorable Minister Delroy Chuck, who has a passion for justice and gender issues. We invite both our ministers, Minister Grange and Minister Chuck, in that order, to bring their remarks.
Thank you so much. Reverend Osborne Bailey, Chairperson, colleague Minister, Honorable Delroy Chuck, Minister of Justice, Mrs. Charmaine Clary Beckford, Acting Chief Technical Director, the Ministry of Justice, the leadership of the Lay Magistrates Association, Justices of the Peace, friends of the media, viewers on the various social media platforms. I greet you this afternoon. I use this opportunity to congratulate the Ministry of Justice for always promoting the important role of justices of the peace in supporting the process of conflict resolution in Jamaica. I commend the Victim Services Division for the ongoing work being done to support victims of violence in Jamaica through the Victims Charter and other services. This session is indeed timely to identify and prevent domestic abuse as it comes against the backdrop of a series of horrific acts of intimate partner violence, which have caused extreme pain and trauma to so many families and communities. My ministry, which is the Ministry of Culture, Gender, Entertainment and Sport, and I want to acknowledge my permanent secretary, who is also online, will continue to work closely with the justice sector to introduce new pieces of legislation, review and strengthen existing legislation to provide greater protection for women and girls. It is recommended that justices of the peace provide support to community members through conflict resolution. This underscores the relevance of this evening's sensitization on gender-based violence among members of the Lay Magistrates Association. Gender inequality poses a significant challenge to the progress of specific sustainable development goals, including the standalone Gender Transformative Goal 5, which addresses the achievement of gender equality for all women and girls. It also addresses Goal 16, which focuses on peace, justice, and the building of strong institutions. The National Strategic Action Plan to Eliminate Gender-Based Violence 2017 to 2027 facilitates a coordinated response to gender-based violence. This includes working cohesively with several MDAs, ministry departments, and agencies, working closely with private sector, civil society groups, and other key stakeholders to tackle the scourge of gender-based violence. I want to say this afternoon that I look forward to more sessions like these to continue the conversation on the critical role of gender equality and peace building. It is my hope that you will leave the session with an understanding and increased awareness and appreciation of the complexity of gender-based violence and the commitment which you are required to make to support the conflict resolution framework and gender architecture in Jamaica. On my part, and the ministry's part, we are doing all we can. We hope that before the end of this month, we would have tabled the amendments to the Domestic Violence Act, as well as the Sexual Harassment Act. And I look forward to continuing to work with my colleague minister and his team to ensure that we are able to address this very, very difficult situation of domestic violence. So all the very best for a most fulfilling session, and thank you so much for inviting me. Minister Chuck, thank you.
Thank you very much, Minister.
Yeah,
Minister Chuck?
thank you very much, Minister Grange. Thank you, Reverend Bailey. May I just also thank all the justices of the peace who have joined us on this webinar. I know there are others who will be watching on PBCJ and Facebook and so on. This session really came about because Reverend Ian Murid showed me a number of slides, notes as to how we can anticipate where there's likely to be domestic violence. And I thought that the presentation from Reverend Murid was so good. I thought it necessary that he should share it personally with the JPs, and I hope he will get the opportunity to share it with a wide cross section of Jamaicans. Domestic violence, partner abuse are really a pandemic at this time. And it is absolutely important that every single one of us really play our part to ensure we reduce domestic violence. So I'm not going to add much more than to say we have online. When I checked at the beginning, close to 400 justices of the peace joining us, and it's likely it may have exceeded that number now. The main presentation will be from Reverend Ian Murid, and I really would like him to get on with it. So I just want to thank everyone who has joined us and wish for you an enjoyable and informative evening. Thank you very much, Reverend Bailey.
We thank you, honorable ministers, and I just want to note that there are actually over 550 participants online, which would require us to work diligently with one another. Keep your mics mute, remember, and follow the protocols we spoke of earlier. And it would be nice if you wrote your name so that just in case you have to ask the questions in the chat, we will know who is the person who is asking the questions. Thank you so much. We have indeed an erudite panel of presenters tonight, all experts in their field, who are here to enlighten us on various aspects of this issue. We would like firstly to ask Ms. Georgette Grant. She's the legal officer in the Ministry of Culture, Gender, Entertainment, and Sport to speak to us this morning. She comes out of the office of the Permanent Secretary. Ms. Grant, it is our pleasure to have you.
Thank you so much, Reverend Bailey. Good evening, everyone. To based on what I'm seeing here, Reverend, 563 participants online this evening. Good evening to you, and it is my pleasure to be with you. I hope that at the end of this presentation, and even while it is going on, that we will get clarity where we were unclear before as to different sections of the legislation, and it will make certainly for interesting questions when the time comes. I'm going to share my screen. Reverend Bailey, please let me know if you are seeing it when I do so. Are you seeing it?
She's coming up. Yes.
All right. And you should still be seeing it at this moment.
Most definitely in presentation view.
Okay, thank you very much. All right, so without further ado, let's get to it. When we talk about the Domestic Violence Act, and it has come more into focus in recent months, Minister said that much in her opening remarks. So I'm just going to take you on a little trip. I summarized the act, certain sections as best as I possibly could, and I'm also going to share with you the amendments that are going to come in very, very short order. So when we talk about the Domestic Violence Act, just a little background here, it was initially passed it first came about in 1995 and it came into force on May 6, 1996 and was last amended in 2004. What the Act seeks to do is to protect victims of domestic violence through the provision of certain remedies like the protection and occupation orders, which we will get into in a little while. And the Act is divided into three sections. Part 1 deals with the preliminary sections of the Act. Part 2 deals with the application for orders, and we're talking about the protection and occupation orders here. And Part 3 is the general section that addresses, we're going to get to some of those general sections so far. Are you hearing me, Reverend?
Yes, you are most clear.
Okay, I saw something about no audio. That's why I was asking.
Well, most clear.
Thank you. All right, so to whom does the Act apply? When we talk about the Domestic Violence Act, who are the persons or the categories of persons that the Act applies to? And I have them here for you. Applies to a child or children, as the case may be, spouse, persons in visiting relationships, a dependent. And when we talk about a dependent, even though I'm going to share that with you a little later, we're talking about persons who, for some reason or another, might suffer from certain mental disabilities or other disabilities that render them dependents and members of the same household. So these are the categories of persons that the Domestic Violence Act applies to. So when we talk about child, the Act defines a child this way, and I put all that the Act says here because it could be a child could fit into one or the other category as is here. So a child could be, well, is a person who is under the age of 18 years, who has never been married, being a child of both spouses, who resides or immediately preceding the date of the application before the court was residing in the household residence. So it could be a child of both parties, both spouses, under 18 years, never been married, that's a child under the Act. Could also be a child of either spouse. So this is a child who has now become a child of the family or a child of the union, as the case might be, who resides or immediately preceding the date of the application was residing in the household residence, the same household, and who is or was living in the household as a child of the family. A child could also be whether or not a child is a member of the household at the time the application is made to the court. You must show that this child is or has been a member of the household or resides in the household on a regular basis, or there's a member of the household that is a guardian of that child. So whichever of the categories such a child falls into, that child is recognized so to be a child under the Act, and as such you can make the application. Now, when we talk about dependents, we're talking about a member of the family of a respondent being a person who is 18 years of age or older and normally resides on a regular basis with the respondent, and a person who by reason of physical or mental disability, age or infirmity is reliant on the respondent for his welfare or maintenance. And he's there. I saw something earlier in the chat, Reverend Bailey, about gender neutral, just to make the point here that it's neutral, okay? It is a neutral term. Okay, So when we talk about member of the household, we're still in Section 2. And Section 2 of the Domestic Violence Act, as in most pieces of legislation, it's the interpretation section. So it defines certain terms that are used in the legislation, and it gives you greater clarity as you go through the legislation what the terms mean within the context that they are used. So member of the household, according to Section 2, means a person who normally resides or resides on a regular basis with the respondent, and throughout the legislation as you read, member of the household is so defined. Okay? Right. Hold on a moment here. All right. So when we talk about visiting relationships, so earlier we established that the act applies to spouses, but it also applies to persons who are involved in visiting relationships. And the usage of the word visiting in and of itself tells us that these two people do not live under the same roof, but they are involved in a relationship, certainly, and they have need to go to, it could be each other's premises from time to time. Are they covered? Yes, they are. And the Act defines visiting relationship as a relationship between a man and a woman who do not share a common residence, which is a close personal relationship by nature of its intensity, and it has regard to the amount of time that they spent together, the place that the time is ordinarily spent at, the manner in which the time is spent, the duration of the relationship, and if there is a child, if there's a child of either party, then that child in that visited relationship would also be covered, meaning an application could be made for such a child. So who are the persons that are eligible to apply for protection orders or occupation orders? A lot of times I notice that when we speak about the Domestic Violence Act, there is this consistent reference to protection orders, but we don't speak a lot about occupation orders, and the two are covered in Section 3. So these are the persons that are eligible to apply: a spouse or a parent, in respect of whom the alleged conduct has been threatened against. So this is conduct that has been threatened against you as a spouse, you can apply, or a parent, you can apply. And these persons that I'm going to tell you about now are persons that are eligible to make applications to the court on behalf of children or dependents. So a person with whom the child or dependent normally resides or resides on a regular basis can make application on behalf of such a person, a parent or a guardian, a dependent who is not mentally disabled, a person who is approved by the minister responsible for social welfare to carry out social welfare work, or a constable, and a member of the household or somebody who is in a visiting relationship with the respondent. So these are the persons where conduct is threatened against a child or a dependent, they can apply. Now, in determining whether the court is going to grant leave to a constable who wishes to make the application on behalf of such a person, or another person who is not a member of the household can also apply but has to get leave of the court. The court has to take into consideration the wishes, what is the petition saying that has come before them, what are the parties saying, what is the reason that they should allow this person to make the application on behalf of the affected individual, the best interest of the person that they're applying on behalf of, and is there any conflict of interest between the person that is seeking leave and the person that is allowed to apply. Okay. Section 4, subsection 1, paragraphs 8E, Roman numerals 1 to 5. In the present Act, the Domestic Violence Act, this section lists out the behaviors when an application for protection order is made. The court normally takes into consideration, based on what is outlined in this section, the type of behavior that they will prohibit the respondent from engaging in. And those behaviors are outlined in section 4, subsection 1, paragraph 8E, Roman numerals 1 to 5. And these are they. So, depending on the application before the court, what the circumstances are, the court might prohibit the respondent from entering or remaining in the household residence of any prescribed person. And when we talk about prescribed person, we go back to the persons that I indicated to you, the categories that are covered under the Act. So that is what that means. Also, from entering or remaining in any area specified in the order, being an area in which the household residence of the prescribed person is located. From entering the place of work or education, from entering or remaining in any particular place, meaning if this is a place that I am known to frequent and the court says, listen, D is a part of the protection order that I am granting to Georgette Grant, then the person should ensure that they are not in this space. They should not be present in this space, should not enter and should not remain. From molesting a prescribed person by watching or besetting the household residence, place of work or education, following or waylaying in any place, making persistent telephone calls, using abusive language to or behaving in a manner which causes annoyance or results in ill treatment, damaging any property owned by or available for the use or enjoyment, or any property that is in the care or custody at a residence that I either own or I am known to frequent. What does the court look at under this section? That's subsection 2 of section 4. What do they look at in determining whether or not they should grant the protection order? And the section makes it clear that the court may make the order if the court is satisfied that the respondent has used or threatened to use violence against or cause physical or mental injury and is likely to do so again. And having regard to all the circumstances before the court determines that, listen, it is necessary for the protection of this person, so I am going to grant the order. There are different types of protection orders, and I use types loosely, but just to allow you to distinguish between the different stages, if you please, of a protection order. So we have a situation where both persons, so Reverend Bailey, forgive me, I'm just using you as a point of reference. So if I make an application to the court, the respondent is Reverend Bailey, then he would be served and we both would come before the court. This is what I term as in-person protection order. So both parties would be brought before the court. The court would read the affidavits that I would have gotten someone to write on my behalf, either the clerk of the court or whomever, outlining why I'm seeking the protection order. And he's also there as a respondent to answer whatever questions the court might have. So both parties together in the court, it's done personally. That is the normal course for protection orders to be personally dealt with and personally served. Now, when we first appear, the court can do a number of things. The court can decide based on the strength of the arguments that it's necessary to make this protection order final. All that I have heard, all that I have read is sufficient. I am so convinced that I'm going to make a final order. Or it could be a case where the court determines that I probably want to follow up in the next 6 months or so to find out what is going on. So I'm going to make an interim order, an order in the meantime to see what happens. And we have interim orders. And it is really so that the court can make an assessment at the next time that we both come before the court to find out what is going on. Do they need to make a final order or whatever other orders that the court is empowered so to make? So we have interim orders, and I just put here about section 13. I'm going to explain that in a little while. Ex parte protection orders. No, this is a situation where the circumstances are so serious that if I was to let whomever I'm complaining against know that I am going to the court to ask for a protection order, it is likely that I might be seriously harmed. And so to prevent a situation, I go by myself secretly and I make the application to the court. This is ex parte, meaning without notice. So the other person that I'm asking the court to grant the order against does not know, even though he or she, because males can do it too, will eventually know, but certainly at the initial stages, such a person will not know. We call those ex parte protection orders. And an ex parte protection order, occupation orders, can also be ex parte. I'll come to that in a little while. The court can make, if it is satisfied that any delay would cause risk to the personal safety of the person or serious or undue hardship. Now, when the ex parte protection order is made, it's done on an interim basis. Interim basis. That is because the other person whom the order is taken out against has a right to know, deserves to know what is being said about him, what is being said about her. So the court will grant the order in the interim. And in practical terms, what that will look like, let us say, for example, I am complaining that he is beating me night and day, I have no peace, etc., etc. When I go to the court agrees with me that the situation is so serious and grants me this ex parte protection order, I will go home with a police. The police will serve that order on I beg your pardon, I'm just going to stop right here. I keep seeing something about an annotation request. Is that from you, Reverend, or is that something that you will deal with?
You just continue with your presentation. Cool.
Okay, so with the police will come with me, and the police will serve the order on the person. If the person is not home, okay, fine, but the police is going. The intention is for the order to be served on the person. But in the meantime, I have the protection of, and it could be a situation where the court decides that they need to make both a protection and an occupation order. So I go home, depending on which section the court says. If the court says, okay, 4(1)(a) to E, 1 to 5, that covers all the situations presently as constituted under the Domestic Violence Act. And the court says, okay, I'm also going to make the order that you occupy the house. So the respondent is not allowed to enter the house, remaining anywhere, the yard nowhere. So you are to have full control until when next you both come. I have the protection in the meantime of being in that home. He's not to be there. She is not to be there. And he or she is not to engage in the conduct which the court has expressly said such a person is not to engage in. The next time when the matter comes before the court, because remember I said ex parte orders are interim orders. So the next time when the matter comes before the court, both parties will now be before the court. And the court will ask for certain intervention by the police. I have seen it done to ensure that the applicants that no harm comes to the applicants, and that they do it in a tactful way to ensure that the respondent does not return to the premises and just ensure the overall safety of the applicant until we return. Okay, so going back to section 13, says every interim order made under this act on an ex parte application shall specify a date for a hearing, which shall be as soon as reasonably practicable thereafter, to determine whether an order shall be made in substitution for the interim order. And the copy of an interim order which is served on the respondent shall notify the respondent that unless the respondent attends court on a date specified therein to show cause why an order should not be made in substitution for the interim order, the court may discharge the interim order and make an order in substitution therefore. What that really means is that when you're served with the interim order, it's going to tell you this is the next date that you're supposed to come to court. And if you want to dissuade the court then from making this interim order final, the onus is on the respondent to turn up on that date and to indicate to the court why this should not be done. And the court will listen to both arguments and determine what is to be done. Other orders that can be made at the time protection or occupation orders are made, the court can also take into its consideration matters of maintenance if children are involved. And so they will look to the provisions of the Maintenance Act. And in cases where you have a dependent, they will look to see is such a dependent entitled, to be maintained, and can make those what we call ancillary orders along with the protection or occupation order. Now, Section 5, which currently houses what happens in the event of a breach. So it deals with the breach of a protection order. The current penalty says $10,000 or 6 months imprisonment, or to both such fine and imprisonment. I want you to take note of paragraphs A and B that both say that where a protection order, whether interim or otherwise, is made and it's served personally on the respondent, so the protection order must be served on you, the occupation order as well, and B, the respondent contravenes the order in any respect, So regardless of how slight it might be, it matters not. Then this is the penalty that you are going to endure. So the breach has to occur. Whose duty is it to inform the constable who can arrest that a breach has occurred? It would be the applicant. So the applicant would have to indicate to the police, listen, I have a protection order from the court or an occupation order, as the case may be. This is what the order says, because you will normally get a copy indicating what is not to be done. And this is what such a person has done in contravention to the order. And the constable, without a warrant, is allowed to make an arrest. And here I have it for you so you can see. And I have put it in bold and underlined certain key parts. So where a protection order is enforced, it has to be enforced. It cannot be expired. Where if it is expired, then you would have to go back to the court for a new one. So once the protection order is enforced, once the person has breached the protection order while in force, you make your complaint to the constable. The constable may arrest without warrant once he has or she has reasonable cause, the constable has reasonable cause to suspect that a breach of the order has occurred. And where an arrest is made by the constable makes arrest because it is reasonably necessary for the protection of the prescribed person. So any child, any spouse, any parent, any person involved in a visiting relationship, any dependent, the categories that we looked at before. And these are the things that the constable is allowed to take into account: the seriousness of the act, which constituted the alleged breach, the time that has elapsed since the alleged breach was committed, and the restraining effect of other persons or circumstances. And I put a very important note at the bottom here, that breach of a protection order is a criminal matter, and it's dealt with criminally. So it is dealt with by the criminal courts. So where a protection order has been made and such an order has been breached, a bit of interference, I don't know from whom, could you just mute your mic, please? So where the protection order has been made and a breach of that order has occurred, make your complaint to the constable. The constable makes the arrest. This now is not a matter that would go back to the family court. This is a matter that is the criminal court, and the criminal sanction will apply. That currently being the $10,000 or term of imprisonment for 6 months, or to both fine and imprisonment. So occupation orders. So the protection orders, in simple terms, are the orders that necessitate that there's to be no contact between the parties. So the respondent is to stay away. The respondent is supposed to stay away. The occupation order grants the applicant, once the court is satisfied that there is sufficient evidence so convinced that such an order needs to be made, grants the applicant the right to live exclusively in the residence. And that is in section 7. And the court can determine for how long this is supposed to go on, and with section or sections of the house. There are instances, and I have seen cases where persons are living in, especially in cases where, or even married couples, where such an application is made before the court, and the house is big enough that each party can take a side. The court might determine that, okay, you stay on the west wing and the other party stays on the east wing, and neither of you is to go into the other's wing. I've seen instances like those. I have seen also instances where because parties don't necessarily want to move from the residence because they don't have anywhere to go, and this is the place that they worked and built. Some of them say, okay, judge, I'm not going to leave, but I will build my one room. I have enough land around the back there, and I won't trouble her. As I said, it all depends on the circumstances before the court. The court will determine if that is an acceptable solution. So the occupation order now can be granted to any person who makes it, bearing in mind again the caveat that you has to be one of the categories eligible to apply for such period or periods and on such terms and subject to such conditions as the court thinks fit the right to occupy the household residence. And I said to you earlier that occupation orders can also be made ex parte, and the same principles as to how ex parte orders are dealt with and the issue of service, those things apply here just the same. The court may make an order under subsection 2 only if the court is satisfied that such an order is necessary for the protection of the prescribed person, necessary, or it would be in the best interest of a child, where a child or children are involved. So what is the effect? Even though I've told you already, the legislation in section 9 speaks to what's the effect of the occupation order, really being that you have the right to exclusively occupy the premises. So if the respondent has to go, whether the respondent be male or female, if the respondent has to go, because it is a gender neutral legislation, the respondent just has to go because the court has ordered it so, and the respondent has to find somewhere else and go. Before making an occupation order, the court shall direct that notice be given to any person having an interest in the property which would be affected by the order. And as I indicated to you, that where interim orders are made and another date is set for the matter to return to the court, both persons ought to turn up so that each person can have the opportunity to state their case. There are instances where people choose not to turn up, and if that is the case, then the court only can hear what is before it and will make the order accordingly. Section 12 of the Act, interestingly, Section 12 of the Act deals with household furniture. So the court can also make an order that you can use household furniture, certain appliances, to the exclusion of the respondent. And it says here the furniture, the household appliances, and household effects in the household residence to which the occupation order relates for such period and subject to such terms and conditions as the court thinks fit. And just to say here that the occupation order, well, not the occupation order, this particular order shall continue in force for a period of 3 months from the date of the making, unless the court otherwise directs. And what is important, yes, sir.
I was just asking how much time you will need to wrap up, because we have 3 more presentations to come.
I'm so sorry. Okay. Should you want me to finish in 5 minutes? I can wrap. Give me a time.
Less.
Okay, all right. Let us zip through what is left here. Okay. So let me just.
I have posted a copy of the act in the chat.
Yes.
I think people are following you quite well. So you really will not, we really would not be out of if you were to wrap it up now.
All right, no problem. Point well made. Let me just zip to the amendments then, because I've been noticing some comments coming in from the chat. Some people have been saying quite a lot, and just to say, quite a lot of criticisms were levied at the act, and we took those into consideration. A lot of you will know, well, all should know about the Joint Select Committee that was held to review certain pieces of legislation, of which the Domestic Violence Act was one. And just to indicate some of the amendments coming, there is no definition for domestic violence currently in the Act, and that's something that is going to be remedied. So domestic violence is now going to be defined as a type of abuse that includes physical, sexual, emotional, and psychological abuse. It will also include instances where persons use various other means, such as exposing intimate pictures of former partners to the public, to inflict reputational and emotional harm on the victims, and in instances where third parties or accessories are used to harass or inflict harm on the victims. Other amendments, it was noted and there was strong advocacy around the fact that there are some entities that are not able to make applications for certain affected categories. For example, like the Office of the Children's Advocate, the Bureau of Gender Affairs, the Women's Resource Outreach Center, and in cases where even people are not members of the household. And so these are some of the things that we sought to remedy in the amendments coming. So the Children's Advocate, the minister being given residual powers to empower certain entities like the Bureau of Gender Affairs, the Women's Resource Outreach Center, to make applications on behalf of affected persons. And I have futuristic down here because another amendment is to give the minister power by order to make changes to the list of persons. So as time goes on and other agencies or entities come up that have certain mandates, the minister can make those by affirmative resolution of both houses of parliament to include other agencies. Okay, we looked at a little earlier on about the behaviors that the court will prohibit the respondent from engaging in. Just to say it to you really quickly, since my time is limited, that this list will be expanded.
Your time is actually up.
Okay, then. So these behaviors will be expanded. So from A to E, it will now be from A to K, and I leave that there. And just to indicate that the penalty, which I saw somebody saying in chat is so low, the penalty will be increased. We are looking at $1 million or imprisonment for 1 year. And thank you very much for listening. I trust I was very clear. Thank you very much, Reverend Bailey, for reminding me of my time. And it was good to have been with you all.
We thank you so much, Ms. Grant, as we pursue support for the advancement of the fight against domestic violence, and appreciation of the law is very relevant. And I believe the participants, only out of anticipation for the other presentations, why they would not want to listen to you in full. And again, we look forward to hearing from you continually. Please remember to keep the chat, it's nice, and people are responding, and you can respond to some of the persons in the chat that has been speaking to your issues. And I see an applaud, so I know that I'm not the only one. Thank you, Anne-Marie. We have some other presentations. The Reverend Ian Muirhead is a senior pastor for the Upper Room Community Church. And what more endorsement can one get than from the minister himself? And so, without any further ado, we invite the minister. He will be making two presentations, one on the characteristics of an abuser, and he will be examining recommendations to be introduced that will help the law to do far more than it is currently doing. As we say, give with more teeth. Thank you very much, Reverend Muirhead. We invite you to take the presentation stage.
Thank you very much, sir. Are you hearing me?
Very well, sir.
Okay, unfortunately, I am not able to access video, but I'm just going to go ahead. I wish to thank the Honorable Delroy Chuck, Minister of Justice, and the Honorable Babsy Grange, Minister of Culture, Gender, Entertainment, and Sports, for this opportunity to present. And I just want to greet everyone in the name of the Lord. I am going to present, first of all, on the characteristics of an abuser. And with respect to, very thankful for the presentation that was just made, with respect to the Domestic Violence Act, I am primarily focusing on intimate partner violence, because I'm very concerned about, the number of women that are being killed, women in interpartner violent relationships, and so I want to begin by stating a definition of domestic violence, which was really given by Reverend Reverend Al Miles, in a book entitled What Every Christian Needs to Know. And the definition is this: domestic violence is a pattern of abusive behavior in which a person uses coercion, deception, harassment, humiliation, manipulation, and/or force in order to establish or maintain power and control. And I want you to note there, in order to establish or maintain power and control over the person's intimate partner or former intimate partner. So it's not a man-woman business. It's not a man-woman business, as it is often referred to, and people say it's a man-woman business. Leave them alone. It's a private matter. We're talking about individuals who are engaging in abusive behavior to maintain power and control over the persons or over persons. So, in terms of characteristics of an abuser, if the person you love or live with does these things, it's time to get help. Keeps track of what you are doing all the time and criticizes you for little things. Constantly accuses you of being unfaithful, prevents or discourages you from seeing friends or family or going to work or school, gets angry when drinking alcohol or using drugs, controls all the money you spend, humiliates you in front of others. Next slide, please. Destroys your property or things that you care about, threatens to hurt you or the children or pets, or does cause hurt by hitting, punching, slapping, kicking, or biting, uses or threatens to use a weapon against you, forces you to have sex against your will, blames you for his or her violent outbursts. Now, the characteristics of abusers, warning signs of potential violence. These are warning signs of potential violence. Abuser pacing the floor, clenching, unclenching fists, facial expression glaring, shouting, yelling. Abuser, shouting, yelling. Always be conscious. Always be conscious of your own safety needs in all interactions involving an abusive person. Do not meet privately with a violence-prone individual. If you must do so, be sure someone is available close by in case you need help. Some other characteristics. Often blow up in anger at small incidents. He or she is often easily insulted, claiming hurt feelings when he or she is really very angry. Are excessively jealous. At the beginning of a relationship, an abuser may claim that jealousy is a sign of his or her love. Jealousy has nothing to do with love. Like to isolate victim. He or she may try to cut you off from social supports, accusing the people who act as your support network of causing trouble. Next slide. Have a poor self-image, are insecure, blame others for their own problems, blame others for their own feelings, and are very manipulative. An abusive person will often say, "You make me mad. You are hurting me by doing what I ask, or I can't help being angry." Often are alcohol or drug abusers. Next slide. An abuser may have a family history of violence, may be cruel to animals and or children, may have a fascination with weapons, and I want us to note there, may have a fascination with weapons, may think it's okay to solve conflicts with violence, often make threats of violence, breaking or striking objects, often use physical force during arguments. And later on, one of the things that I'm going to be putting forward is that, an abuser is someone with, serious psychological disorders. Often uses verbal threats such as, "I will slap your mouth off," "I will kill you," "I will break your neck." Abusers may try to excuse this behavior by saying, "Everybody talks like that," which is not true. May hold rigid stereotypical views of the roles of men and women. The abuser may see women as inferior to men, stupid, and unable to be a whole person without a relationship. They are very controlling of others. Controlling behaviors often go to the point where victims are not allowed to make personal decisions. Next slide. May act out instead of expressing themselves verbally. May be quick to become involved in relationships. Many battered women dated or knew their abuser for less than 6 months before they were engaged or living together. And if I could add, during those 6 months, they are excessively romantic. An abuser may have unrealistic expectations. The abuser may expect his or her partner to fulfill all his or her needs. The abusive person may say, "If you love me, I am all you need. You are all I need." Next slide. An abuser may use playful force during sex and or may want to act out sexual fantasies in which the victim is helpless. May say things that are intentionally cruel and hurtful in order to degrade, humiliate, or run down the victim's accomplishments. They tend to be moody and unpredictable. And this is very, very stressful and terrorizing. They may be nice 1 minute and the next minute explosive. Explosiveness and mood swings are typical of men who beat their partners. They may have a history of battering. The abuser may admit to hitting others in the past, but will claim the victim asked for it. An abuser will beat any woman he's with. Situational circumstances do not make a person abusive. Next slide. Some domestic violence is life-threatening. All domestic violence is dangerous. But some abusers are more likely to kill than others. And some are more likely to kill at specific times. And, in my next presentation, in terms of recommendations, this is the area I am focusing on. Some abusers are more likely to kill than others, and some are more likely to kill at specific times. The likelihood of homicide is greater when the following factors are present. Next slide, please. And I think that our law enforcement agencies, they all persons involved in various levels of the society needs to have more focus on these things. Threats of homicide or suicide. Remember, how dangerous is the abuser? Assessing lethality in an abusive situation. Threats of homicide or suicide. The abuser may threaten to kill himself, the victim, the children, relatives, friends, or someone else. 2. Plans for homicide or suicide. The more detailed the abuser's plan and the more available the method, the greater the risk he will use deadly force. Next slide, please. Weapons. The abuser possesses weapons and has threatened to use them in the past against the victim, the children, or himself. If the abuser has a history of arson, fire should be considered a weapon. 4. Ownership of the victim. The abuser says things like, "If I can't have you, no one can." Or, "I would rather see you dead than have you divorce me." The abuser believes he's absolutely entitled, and I want to emphasize here, he's absolutely entitled to the obedience and loyalty of the victim. Next slide, please. 5. Centrality of victim to the abuser. The abuser idolizes the victim, depending heavily on him or her to organize and sustain the abuser's life, or the abuser isolates the victim from outside support. And part of that isolation is because they know that what they are doing is wrong and that other persons would not approve of it. 6. Separation violence. The abuser believes he's about to lose the victim. 7. Repeated calls to law enforcement. A history of violence is indicated by repeated police involvement. 8. Escalation of risk-taking. Next slide, please. The abuser has begun to act without regard to legal or social consequences that previously constrained his violence, and that includes protection orders and occupation orders. The abuser has no regard for these orders at this time. And my question is, what help does the abused person have in such situations? 9. Hostage taking. He's desperate enough to risk the life of innocent persons by taking hostages. There is a very serious likelihood of the situation turning deadly. Next slide, please. So, I have here typologies of batteries, summary of various studies. And I'm just going to focus on the right-hand column. Psychopathology, personality disorders that research data by the authors in the left column have found as they did research on domestic violence. Marital violence occurred during time of mental disturbance, example depression. Tries to please wife, jealous, very dependent on wife, needs to control wife, uses violence to solve problems. Next slide, please. Unassertive, by Caesar 1986, he found that the abuser was unassertive, dependent, exhibited histrionic traits, psychopathic, and paranoid. Next slide. Over-controlled hostility, more general hostility. Now, I just want to quickly give you a definition of over-controlled hostility. And I want to emphasize, we are not dealing with man-woman issues. We are dealing with men who have some serious, well, they have varying ranges, but who have serious psychological disorders. So, McGargey's over-controlled hostility. Scale to adolescent violent behaviors was evaluated. Such individuals appear to keep tight constraints on their hostile emotions and aggressive behaviors until they explode. Intermittently or fits of violent behavior of great intensity. And I want you to note, of great intensity. Individuals who scored low scores on O-H possess scant ability to control hostile impulses, thus exhibiting frequent angry and possible violent behavior. Right? So, some serious psychological disorders may be present in an abuser. And, you know, we need to take note of that. Okay, so that is the end of this presentation. And my next presentation now has to do with some recommendations which I presented at a meeting with Mr. Chuck, the Honorable Delroy Chuck, and his team. So we're looking at recommendations for the introduction or modification of laws to protect women whose lives are being threatened because of gender-based violence. And I know that I think some of the things that I touched on here might have been were touched on by the previous presenter. All right. Next slide. According to a United Nations report entitled Women's Health Survey published in 2018, 1 in every 4 Jamaican women have experienced gender-based violence. And in fact, this report said worldwide, it was 1 in 4 women. And as I looked at that, I said, it's not just the coronavirus that's a pandemic, but violence against women is a pandemic. It is well documented that abused women develop serious levels of depression, post-traumatic stress, and battered woman syndrome, which places them in a mental state which causes them to be irrational in the assessment of their relationships at times. And, I really want to emphasize this because sometimes we look at a battered woman and like, for instance, her decision to stay in an abusive relationship, and our response might be, what a foolish woman. Isn't this woman an idiot? But the truth is that there's a lot of mental turmoil being experienced by such a person. And, it's not just a black and white situation, so to speak. Often they are told by their abuser that if they leave, they will kill them, a condition which can cause fear and paralysis. From such threats, the state has not been able to protect many women who have been cruelly murdered by their abusers. And so part of my presentation is to try, to make some suggestions as to how the state might be better able to protect women who are being abused and whose lives are in danger of being snuffed out. All right, next. Research data indicates that some male abusers have been diagnosed to have psychological disorders and have been known to use guns, knives, at times to threaten or kill their victims. This is proposal 1. I am therefore proposing that all known abusers who are holders of firearm license should have these licenses terminated. I would also like to suggest that all applicants for new licenses undergo serious psychological assessment and investigation to determine if they are engaged in gender-based violence. Should they be engaged in gender-based violence, I am suggesting that their application for a firearm license be denied. Next slide. Proposal 2. Currently, if the life of an abused woman is threatened, the person making the threat is subject to a meager fine in the petty session court. I think it might be $50. Because of the threat to life that an abused woman faces, I propose that any such threats be treated in a similar way to how threats of crown witnesses are treated. Proposal 3. Because research data indicates that there are times when abusers begin to ignore warnings from law enforcement officers and court restraining orders in pursuit of harming or killing their victims. I propose that consideration be given to include abused women under the Witness Protection Program or some similar program. Proposal 4. I propose that whenever a case of domestic violence comes to the attention of the police, that the abuser be mandated to undergo psychological evaluation by an adequately trained health professional. In other words, not conflict resolution, not couples counseling, in order to assess the level of threat to the abuser and to society. Proposal 5. Currently, the Domestic Violence Act, which is a civil act, provides very little protection for women who are being pursued by spouses who have an agenda to murder them. I propose that this aspect of the Domestic Violence Act be upgraded to a criminal act. Well, I think we heard in the previous presentation that this matter is being addressed. But definitely, there needs to be protection. Proposal 6. In cases where the police fail to respond urgently and adequately to protect the life of an abused woman, an alternative, and that does happen. I know of a case where, a member of my family was abused and the police was called, and when the police came, the first question he asked was, "What did you do to deserve this?" And I'm not saying all police officers are like that, but I'm just sharing an experience. So an alternative source of appeal should be available to abused women. This could be a special desk in the commissioner's office, or an appeal to Indicom, or something, some source where they can make an appeal. Proposal 7. Because of the psychological state of an abused woman, consideration should be given to treating acts of violence against her as acts of violence against the state. In other words, it would require changing laws and, and not treating things as per usual. Proposal 8. I propose that whenever agents of the state recommend counseling for victims or perpetrators of gender-based violence, that they be deliberate in demanding that counseling be administered by persons who are specifically trained to help such persons. This is not a case for conflict resolution, etc. Both abused and abusers have serious psychological disorders. Proposal 9. In cases where it is concluded that an abused woman's life is at risk and the abuser cannot be found, that a public announcement be made giving the name of the abuser as a person of interest who should report to the police immediately. Proposal 10. When a report is made, an assessment of the levels of threat should be made to determine whether there needs to be immediate intervention. For example, removing the woman to a secure place until the abuser is brought in for immediate questioning and risk assessment without breaching constitutional rights. If necessary, modifications of the laws could be considered to facilitate responding to these identified levels of threat. Proposals 11 and 12. If the abuser is found guilty of committing an offense, Should there be a mandated period of counseling, whether the person is in or out of prison? 12. Consideration be given for the retraining of judges, magistrates, lawyers, police officers, health professionals, teachers, etc., so that they may develop greater sensitivity and understanding to victims of gender-based violence. Proposals 13 and 14. A greater role of restorative justice to assist with relationships in the society at all levels. And 14, a national communication plan for social and behavioral change regarding abuse of women. And national communication plan. I think this is very, very necessary because, there is a negative mindset out there. There is an inappropriate mindset that's not very sympathetic to an abused woman situation. Proposal 15, and my final proposal. Effective policy development must be driven by reliable data, as we're having with the COVID situation, on the incidence of violence against women. Must be driven by reliable data on the incidence of violence against women, women's responses to violence, and their need for services. Lack of detailed, disaggregated data collected about femicides by the state represent missed opportunities for appropriate understanding, prevention, and prosecution of femicides. For example, current police data on murders do not disaggregate data to show how many women were killed. Last week I asked, I called an officer and I asked if I could get some information on how many women were killed by domestic violence in 2020. And I was told that, the information, the data was not available in the current format. So these are my proposals, and I thank you very much again for the opportunity for making this presentation, and I turn it back over to you, Mr. Moderator.
Well, and I certainly, without question, can, on behalf of all the participants, thank you. The chat speaks volumes for the support that is being given for all of your proposals.
Reverend Bailey.
Yes, sir.
I think I have a suggestion to see that rather than asking Ms. Robinson to come on now, and there are so many questions and points that have been raised that we should continue this next so that Ms. Robinson can make a proper presentation rather than and also for the JPs to be able to have their questions responded to. What do you say? I mean, you have over 670 GPs on. Would you agree to us continuing next Thursday evening, same time?
Well, personally, I have no objection, Minister. So it is really your colleague justices that wish support that, Minister.
Ms. Robinson, would you be available next Thursday night? I don't think it's fair to put you on now and then to continue until 10. We really want to stop at 9 o'clock, and it is almost 9 o'clock.
If it so pleases you, Minister, Honorable Minister, I yield.
Right. I think it's best for us to invite you back, and then Reverend Bailey has agreed, and I think Reverend Muret, would you be able to return next Thursday evening? Some of the questions that would be posed So we would circulate your presentation, and persons will be able to send questions in, which you will be able to respond to. Would that be okay?
Yes, sir. That will be okay.
And then we'll also ask Ms. George Grant to respond also or to expand on some of the issues that she had to rush. We should have really put it for 2 evenings from the beginning. So just at the piece, I don't want to detain you beyond 9 o'clock. So we are going to continue the session next week, Thursday at 7:30, when Ms. Robinson would make her presentation, and then we have at least hopefully about an hour for interaction, not only between Reverend Bailey and the presenters, but also for you to have some of your questions responded to.
Wonderful.
I think that's the best approach rather than to keep all of us up late beyond 9 o'clock. I don't want to go beyond 9 o'clock. Okay? So if
Yes,
that's
sir.
agreed, Reverend Bailey, I think we should just adjourn until next Thursday evening. I think the both presentations have been wonderful, but I
Yes.
think that the GPs, and I see them on the chat, they
Yes.
really would like to ask some questions, and it's not a preaching, it's not just a monologue, it's intended to be a dialogue. Okay? And I know they would like some of their questions responded to.
And even preaching require a good altar call.
Right. So just for the piece, we're going to try and get the presentation circulated, so that you will be able to pick points that you want to greater clarification or further discussion by the presenters. And I'm sure next week we will have even, greater interaction, which is what I'm hoping for. So Reverend Bird, I want to turn over to you to just sign off.
Thank you so eloquently spoken already, Minister. I did promise you an erudite panel of presenters, and we did not disappoint you tonight, and you certainly agreed by your responses in the chat. I truly want to thank those who made their presentations tonight. We thank the Honorable Ministers of Justice and Minister of Culture, Gender and Sport and Entertainment and Sport. And we want to thank also Ms. Grant, whose presentation is beyond measure. I had put up in the chat a link from the Ministries of Justice website to the act, so you can actually read extensively, so that when you come back next week, the questions can be right. Yeah, Reverend Muirhead, we are indebted to you, sir. Your recommendations go without saying, and I saw the chat. We are in agreement. With that said, I want to thank you all who are here present, justices, custodians, and even I think I saw some visitors and visiting friends. Thank you all very much. We look forward to meet again on this platform next week, Thursday, beginning at 7:30. Thank you very much. God bless you.
Benediction.
To make sure
Okay.
you come back next week and hold the benediction till next week.
I
Thank
I
you,
wanted to
everyone.
make a suggestion before you
Very good
close
presentation.
that we start at 7 instead of 7:30 since there will be so many questions to be asked and answered.